In a debt-related matter, we often see defenses that, while on their face appear to contain merit, actually do not raise a legal defense. As such, banks have a couple options to move forward with the matter, one of which being a motion for summary judgment. This is where the bank will argue, mainly by a written record, but also supplemented by an oral record in a court hearing, that the defense is without legal merit and therefore should be overlooked in favor of the bank. The practical result of this is that if the bank is successful, it leads to a judgment being entered against the debtor, which is basically a fancy way of saying that the court has recognized the debtor owes a specific amount of money to the bank, and therefore the bank can now take steps to get that money beyond trying to settle. There's a misconception that having judgment entered is the dagger. Now the bank will ignore all attempts to settle and proceed with taking all the debtor's assets. More often than not, the bank is willing to engage in continued settlement discussions and aims to resolve amicably rather than proceeding with enforcement methods. However, the bank is not obligated to settle, so it may sometimes seem that there's no desire to settle. That's why it makes sense why debtors can be hesitant to consent to judgment. After all, it unlocks more methods of enforcement for the bank than previously available. However, that hesitation has to be contextualized. The bank proceeds with judgment when it knows there is no legal defense. There truly is no legal defense. It is likely only a matter of time before judgment is granted, so not consenting to judgment is effectively doubling down on the defense. Of course, there are situations where this is worthwhile, but often all this does is delay the inevitable, which in turn only ramps up court costs and has a chilling effect of making the bank less willing to negotiate when it knows that the other side is steadfast and uncompromising. Consenting to judgment also doesn't necessarily mean that enforcement rights become immediately available. In cases of settlement negotiations, an effective tool that both sides can utilize is to have the judgment consented to, but hold said judgment in escrow, meaning pending the fulfillment of specified conditions. This is commonly the case where a settlement agreement depends on the debtor's repayment scheme, for example, by way of monthly payments, where the consent to judgment is held in escrow while the debtor makes monthly payments. If the debtor fails to make a payment, and if the terms of the settlement agreement allow for it, the other side can now file that consent to judgment and proceed to enforce. Otherwise, if all goes well and the debtor sticks to the payment scheme and fulfills all remaining conditions of the settlement agreement, that consent to judgment is destroyed as if it were never made.